Be seated, please. Welcome to today's oral argument docket at the First District Court of Appeal. We have 4 cases on the docket today. They'll be taken, as has probably already been indicated, in the order in which they appear. I don't do this every day, but I'm going to again remind the advocates that that clock that we put on there actually is an operating real-time clock. It's not just there as an adornment to the podium. It doesn't even make the podium look any better. And you should follow that clock, particularly the appellants need to follow that clock because you're the ones that are reserving your rebuttal time, and we don't sort of view it as our job to interrupt an advocate in mid-sentence. So pay attention to your time, and when you get to the end of your argument, by golly, end your argument. Don't make the court cut you off. First case, and after the second case, we'll take a 10 to 15 minute recess in the attorney commons, which is to your right of the court. First case, State versus JMO.
May it please the court, Samuel Prony for the state. I'd like to reserve 5 minutes, please. Before I begin, I just wanted to note that the docket sheet lists Jennifer Moore as counsel. I filed a notice of appearance though on March 16th, so I assume the docket sheet just wasn't updated.
I think we have that actually corrected, but it wasn't reflected on the docket sheet.
Okay. I'd like to begin by briefly going over the facts of this case. On the night of May 5th, 2009, officers were serving an arrest warrant on Willie Steverson, Jr. at Mr. Steverson's grandfather's home. Deputy Rebecca Simpson, while standing on the elevated front porch of the home, turned and noticed 2 young men approaching the house, one of whom she believed was Willie Steverson. Now, she believed this based on her prior knowledge of Mr. Steverson while working at the Escambia County Work Prison, where she observed Mr. Steverson on a daily basis, and based on that recollection, believed that one of the young men was in fact Mr. Steverson. At that point, both the young men saw Deputy Simpson. Deputy Simpson, her exact words were, "Hey, come here," directed towards the young man we now know as JMO, but who at that time Deputy Simpson believed was Mr. Steverson. At that point, JMO backed up, turned around, and engaged in a headlong flight away from law enforcement. At that point, Deputy Simpson directed JMO to stop, identifying herself as a sheriff's deputy. But at that point, JMO was still proceeded to engage in his headlong flight away. Deputy Simpson stated that she directed him to stop a minimum of 3 times, but JMO continued his flight. Now, at the time that Deputy Simpson saw JMO, Deputy Sean Thompson, who was also at the scene, was walking around to the front of the house and saw Deputy Simpson and the person we now know as JMO with the light shined on JMO as well as the other gentleman, and he believed that the same person Deputy Simpson thought was Mr. Steverson, JMO, was Mr. Steverson as well. He based his belief on the fact of the description he was given prior to them serving the warrant.
It sounds to me like, correct me if I'm wrong, like you're arguing that no competent substantial evidence supports the trial court's initial factual determinations. Well, you're making a purely factual argument. Is that your argument?
Well, the problem with the...
Is that your argument?
Yes. The problem with the trial court's order and the findings at the suppression hearing was that the court doesn't make any specific factual findings as to why the motion is being granted. The court does deal with the physical dissimilarities between JMO and Mr. Steverson, which there was some back and forth at the suppression hearing in terms of what that exactly was. Deputy Thompson, he was with the K-9 unit, and he released the K-9 who ultimately apprehended JMO. And he testified that when he reached JMO, JMO said he was 6 foot, 180 pounds, I believe. And the description he had was, I think, 5'10", 175.
I'm losing you on what your legal argument is.
Well, the legal argument is that, that the trial court appears to have focused too heavily on the physical dissimilarities between both JMO and Mr. Steverson. And the
standard of review is on findings of fact, we have to review them in a light most favorable to the trial court's ruling. So any inferences, any doubt as to the trial court's factual findings are going to be resolved in favor of the defendant in this case.
But I think the problem with this case is that the court doesn't specifically make any findings of fact. What the court does is the court focuses its attention on those physical dissimilarities between the two and doesn't take into consideration the totality of the circumstances that
If the
were
court had
involved.
said on, it came to mind when I was reading this case what the setting was. This was a case that was in juvenile court in Pensacola, and most juvenile court proceedings take place in a courtroom, especially a motion. I think this was a motion to suppress. There's a bunch of people there. There's cops. There's we used to call them HRS. I don't even know who supervises juvenile delinquents now. But there's all kinds of people in the courtroom. It's probably not a closed hearing. And it seems to me, and I'm looking at several excerpts from the record, that the judge did go on and on and on about what the actual issue was in the case, which is the threshold issue, which y'all haven't talked a lot about in your brief, and does make a lot of observations that appear germane. But my question is, if this judge had simply said, I don't believe the officers, where would that leave us?
In terms of the resisting
Right.
without violence? Well, I mean, that would be a different situation, but, I mean, that's
Well,
not...
I don't know that it is. For instance, he says at page 56 of the transcript, and that gets us back to a warrant issued for a person some 10 years older than this defendant with differences in height to denote whether it's 3 or 6 inches and some difference in weight, and there was a substantial difference in weight. And he makes a number of other observations that I'm sure you're more aware of than I am.
But I think...
What more did you want him to do? Are you saying you need
I
a written
wanted-
order with findings of fact? Is that what you're saying? Would you like us to apply that law the other way?
Well, it appears that...
Consensual searches and things like that?
No, it appears that the judge didn't take into consideration the other factors that made the police officers believe that this was Mr. Steverson, in fact, reasonable. He failed to consider the fact of...
Counsel, let me again, I'm not sure I understand your legal argument. Let's change the context a little bit here. Let's say that the testimony of the officers was that they asked this young man, this juvenile JMO, to stop, and he did so willingly, and then they said, may we search you? And he said yes. And the officers testified to those two facts. Then JMO testified and said, no, I didn't even know there were policemen. I turned around and ran. Would that search be upheld or not?
Well,
it would be upheld, wouldn't it?
Yes, because
if the court believed what the officers were saying.
Yes.
So isn't the situation the same here? Even though it's a rare instance, isn't it the same legal analysis?
No, because I think what the trial court was doing, it wasn't necessarily coming out and saying, I don't believe the deputies in this case. The trial court seemed to be saying that based on the fact that JMO is not Mr. Steverson, based on the fact that there are height differences and weight differences between the two, that it was presumably unreasonable for them to believe that it was Mr. Steverson.
Counsel, what you're doing, though, is you're disagreeing with many, many observations that this judge made. Now, you and I are free to disagree with what the judge said, but we're not free to disagree with what appear to me to be factual conclusions unless they're not supported by any evidence. This is not what I'm trying to say. This is not a hearing on a motion to suppress. This is an appeal.
Correct. And the reasonable belief of the officers that this was Mr. Steverson, that gets to the threshold issue of when they ordered him to stop and he continued to fly, his headlong flight.
It's not the threshold issue.
In terms of the reasonable belief, whether or not they believe this was Mr. Steverson?
Is what their basis was to order him to stop.
Their reasonable belief that this was Mr. Steverson, based on not only the...
Your belief that their belief was reasonable, and perhaps our belief that their belief was reasonable. But that's not the fact that this case comes up with.
Well, I think if you look at the CEL case and the Wardlow case, discussing what gave rise in those cases to the officers ordering the defendant in those cases to stop, it wasn't one particular thing. It wasn't just the high crime area. It wasn't...
Why don't you summarize succinctly the factors that gave the officers reasonable suspicion and that are factually established, essentially beyond dispute or by overwhelming evidence,
The first fact would be Deputy Simpson's prior interactions with Mr. Steverson, where she saw him on a daily basis, was familiar with his physical appearance, testified that his weight varied. Deputy Thompson's independent belief that JMO was Mr. Steverson based on the photo and description he received. The fact that JMO was approaching the home where Mr. Steverson lived, which would be the equivalent of a high crime area in Wardlow, and that it's the physical characteristics of that particular location. The fact that neither Deputy Simpson nor Deputy Thompson believed that the other person with JMO was Mr. Steverson at all. The fact that when JMO turned and ran and they told him to stop, he continued to run.
Nobody disputes that whoever this person was continued to run. It turned out to be JMO. But so what is the legal basis on which the trial court erred in rejecting those factors? Your argument is essentially, as I understand it, a trial court based on these facts cannot find there was no reasonable suspicion.
No, the problem is that the trial court isn't saying, based on all those facts, it's not showing that it considered all those circumstances and finding out whether or not, or determining whether or not it was reasonable for the officers to order JMO to stop. It seems like the trial court is relying...
Counsel, if we went with your view, let's assume your view is correct, because it may well be, that unless on the record it shows the trial court considered all these factors, I would not want to be one of your colleagues tomorrow arguing in favor of a consensual search.
But I don't think this
We
is...
get hundreds of those, and that's not the way they're ruled upon.
But I think in this case, the officers were there to serve an arrest warrant for Mr. Steverson. They believe Mr. Steverson...
Counsel, you've said that so many times, and I know you're saying it in good faith that they believe that, but I cannot read this record, and I'm looking at transcript 52 through 59, and conclude that the trial judge agreed with it. I just can't do it. Now, can you?
I'm not saying that...
Can you read the trial judge's statements and conclude that the trial judge concluded that these two officers reasonably believed that this man was Mr. Steverson?
No. I mean, the trial judge is not specifically saying whether or not they reasonably believed that he was JMO was Mr. Steverson or wasn't. The trial court just grants the motion. And the only things that the trial judge emphasizes are the physical characteristics of JMO and Mr. Steverson. What we're arguing is that...
Did you state, I'm not, maybe I missed it in your brief, but is this being justified as a Terry stop? You haven't argued that.
No, this is not a Terry stop.
In your brief, it was based solely upon service of the warrant.
Correct.
So I'm not sure what the circumstances are you're talking about.
Well, the circumstances...
What was the flight was in response to what?
The order to stop.
Right. So it's the order to stop we have to focus on.
Right.
Can't you see that? It's the order to stop that the judge focused on.
And the order to stop was justified based on the fact that the deputies were there to serve...
That's the issue in the case, counsel, whether the order to stop is justified or not. And in the brief, which I recognize you didn't write, it doesn't seem like your office grappled with that issue.
Well, I think the basis for the officers to...
Because we have to find there's no competent substantial evidence to support the trial court's implicit finding. I think you'll acknowledge that there's an implicit finding that he doesn't find the officers credible, that he doesn't believe that they thought he was Mr. Steverson, that they thought this person was Steverson, right?
Well, the problem is I don't know what the court is relying on solely.
Let me try it again. Don't you think the implicit ruling here from the trial court is, I don't believe the officers. I don't believe they thought he was Mr. Steverson, and if they're telling me they thought he was, I find there's no reasonable factual basis for their mistaken identity.
That would have to be assumed since the trial court granted the motion.
Right. So we assume that. So for you to prevail on appeal, you have to show there's no competent substantial evidence to support that factual finding, right? Reviewing the facts in the light most favorable to the trial court.
Correct.
Middle of the night, difference in height and weight.
But I think the fact that it's in the middle of the night, that also it's not midday, it's not clear conditions.
So you're arguing that's okay. That's in favor of the officer's testimony.
Correct. I see that I'm running out of time, so I'd like to reserve the rest of my time for rebuttal. Thank you.
Gifford.
Good morning. I'm Glenn Gifford from the Public Defender's Office, Second Judicial Circuit, and I'd like to introduce Benjamin Cooper Lord, certified legal intern who prepared the answer brief under my supervision. We'll be arguing on behalf of the appellee today.
Mr. Lord.
May it please the Court. My name is Benjamin Cooper Lord, and I represent the appellee, JMO. The appellee asks this Court to affirm the decision of the lower court and dismiss the charge of resisting arrest without violence. As Your Honors have stated, the only issue in this case is whether there was competent substantial evidence to support the trial judge's finding that the reasonableness of this stop, that this mistaken identity was not reasonable. And based on the facts in this case, that there was a substantial difference in age. There was 10 years of difference between these two individuals. And there's differing testimony and evidence in this case, but there was 5 inches, but based on the 2 pieces that were introduced into evidence by the defense counsel, and 33 pounds of difference. Based on those 3 pieces of evidence, as well as the time of day, it was late at night, based on the vantage point of the identifying officer, Deputy Simpson, who testified that she was 3 to 4 inches off the ground when she identified JMO as the person, as Mr. Steverson. She herself said that she wasn't able to judge how tall he was based on that vantage point. Based on all this information, that supplements the trial judge's finding, his findings of fact, and his implicit finding by granting this motion to suppress and dismiss that the...
Why shouldn't we, Mr. Lord, apply the tipsy coachman rule in this case to determine that this was a legitimate Terry stop, and had your client simply acquiesced, it would have been over very quickly since he didn't have any contraband?
Well, yes, Your Honor, under that factual situation, then the officers might have been able to determine that he wasn't the individual that was in this arrest warrant.
That's not my question. My question is why shouldn't we determine that this is a Terry stop?
Because, Your Honor, the only reasonableness, the reasonable suspicion is based on the reasonableness of the officers in determining that the appellee was this other individual.
Terry stop wouldn't matter who he was. He could have been you or me. If they had reason to stop him, might as well have stopped him first of all.
Yes, Your Honor, but the officers never testified that there was any other reason for stopping this individual. The only reason that these officers stopped the individual was because he was allegedly this other individual, Mr. Steverson, that was in the arrest warrant.
What do you say to your opposing counsel's argument that the fact that it was in the middle of the night, that a reasonable person could have easily mistakenly identified this person as someone they thought they knew?
Well, yes, Your Honor, and I think that the Second Circuit in Rios v. State said that the reasonable suspicion requirement requires more than just a hunch. And I think by...
Well, there was a lot more than a hunch here, right? They saw him every day in the work camp. They knew who Steverson was.
Well, yes.
They see this person walking up to the house where Steverson lives, and they think, that's Steverson, and they tell him to stop.
Well, yes, Your Honor, based on... There is some evidence that might...
In other words, I think what I'm getting at now that I hear the arguments a little more in detail is we have to assume what the trial court ruled here is that they had no grounds for thinking this person was Steverson, right?
No, Your Honor. No, we need... This court needs to look and see if there's competent substantial evidence to support the lower court's implicit finding that the mistake by these officers was unreasonable.
Okay. Well, why was it unreasonable? Because we know... I mean, the fact that it was a mistake is not the issue, right?
No, Your Honor.
Okay. So the question is there competent substantial evidence to support the trial court's ruling that this was an unreasonable case of mistaken identity, right?
Yes, Your Honor. Because of the... As the trial judge elaborated on, because of the large difference in age, 10 years, in height, 5 inches, and in weight, 33 pounds. Because...
So if there's a car accident out front here while we're in the courtroom, and a witness said, gosh, it happened so fast, it was a yellow car, and there were 3 people in the car. And then you take the witness's deposition, turns out the car was red, and there were 2 people in the car.
Yes, Your Honor.
Was that person unreasonable in mistakenly thinking it was a yellow car with 3 people?
Your Honor, that might have been a good faith mistake. However, it wasn't a reasonable mistake. Maybe it was reasonable because of because it all happened so fast and because they weren't able to make. But it wasn't reasonable under all of the facts in your scenario, Your Honor. And again, in this case, we have the trial judge finding that there was numerous differences between these individuals. And while the officers in this case testified that there was some NMI information sheet, which was never submitted and never introduced into the record, that listed Mr. Steverson as 5'10" and 175 pounds, evidence that was submitted immediately after he was arrested, less than a week later, found that he was 5'8" tall and 147 pounds. Now, while Deputy Simpson testified that his weight fluctuated while he was in the Escambia County Road Prison, I don't assume that his height fluctuated at all. In other words, I don't assume that he shrunk 2 inches in between these two. So this is another difference in testimony and in evidence, which the trial judge might have used to find the officer's testimony was incredible. The other piece might have been that it was, that the appellee testified or told the officer that he was 6 foot when he was measured at 6'1" when he was arrested. That the Deputy Simpson testified that she recognized his build and hair color, even though it was late at night. The lighting conditions were very poor, and for her to make a determination on his hair color based on the distance between these two individuals and the poor lighting conditions, these are all things that could give the trial judge pause.
You're also arguing the facts very intensely. Let me follow up on what Judge Thomas asked, and ask what do you see the issue to be in this case?
The only issue in this case is whether the trial judge based his grant of the motion to suppress and dismiss on competent substantial evidence that the officers were unreasonable in their mistake of the appellee for this other individual, Mr. Steverson. And as I previously stated, there is plenty of evidence, plenty of competent substantial evidence that would give the trial judge that reason to.
Okay, well, we can disregard the fact that he wasn't Steverson. That's the ultimate issue, so that doesn't count.
Yes, Your Honor.
So he basically talked about during the hearing the height difference. What was the height difference?
Well, Your Honor, the height difference between these two individuals, as evidenced in Defense Exhibit 1 and 2, was 5 inches. Mr. Steverson was 5'8" tall, and the appellee was 6'1" tall. Now, again, the officer stated that there was some NMI information sheet, which I haven't seen, which said that he was 5'10" tall.
Well, okay, 5 inches difference in height. What are the other factors the trial court implicitly relied on?
The 33-pound difference and the 10-year difference, which was not in dispute.
How good a look did the officers get at your client?
Well, they testified that Officer Simpson, who made the identification, saw him while she was standing on the porch and while he had just turned into the walkway. So however long the walkway was, and there was no evidence as to exactly how long that was, that was the distance, and she said that it was a pretty fair distance between herself and the appellee. So there was a pretty fair distance. She couldn't judge the weight of the appellee based on her vantage point, and she testified to that. The lighting conditions were poor. There was apparently a porch light, and there was light from cars that were down the street and a street light that was 4 to 5 houses down the street, and they had their flashlights. So it was based on those lighting conditions and that vantage point and the distance that she made her identification. Now, Deputy Thompson, when he also said that he identified the appellee as this other individual, it might have been because Deputy Simpson had already identified this individual as the appellee. And while they're all on this property looking for this individual, Mr. Steverson, if one of the officers who admittedly has most of the interaction with Mr. Steverson has already identified, it's understandable why Deputy Thompson would think as well that this individual, the appellee, was Mr. Steverson. And, Your Honors, this Court has to grant a presumption of correctness to the lower court in their implicit findings of fact that this was based on substantial competent evidence, this mistaken identity between these two individuals. The 3 cases that were cited by the State in their reply brief all go to the same conclusion, that, and they all cite to the Supreme Court in Hill v. California, which says when the cops have the warrant to arrest one person but mistakenly arrest another person, that arrest is valid if the mistake was reasonable. Now, in those 3 cases, the situation is slightly different because those cases found that the trial court found that the mistake was reasonable. And here we have the trial judge saying that the mistake was unreasonable. But in all of those three cases, the court found substantial competent
Do you
evidence.
have any law on whether that determination is a purely factual determination or whether it's a mixed question?
Your Honor, in McRae v. State, reading from the case, it said there was evidence to support the trial court's factual finding that the officers reasonably and in good faith mistook McRae for Johns. And in Borda v. State, another case that was cited by the state, that also went to a factual finding that was supported by competent substantial evidence. So the determination by the trial judge that this mistake was reasonable was a factual finding, an implicit factual finding in its grant of the motion to suppress and dismiss. And the trial judge is in the best place to make this determination because they are able to assess the credibility of all the witnesses. The trial judge can see the appellee who was sitting there at the time. And
What about the flight?
Your Honor, the flight standing alone is not enough to give reasonable suspicion.
I didn't ask if it was enough standing alone. What about the flight in comparison with their thought that this was Steverson?
Your Honor, would that be in addition to their...
Doesn't that support the state's argument that the trial judge's factual finding is not supported by competent substantial evidence? You have one person say, testify under oath, I saw this guy all the time. I thought it was Steverson. It was in the middle of the night. The lighting was poor. I told him to stop, and he turns around and runs away.
Yes, Your Honor.
That's a factor, right?
Your Honor, I don't believe it's a factor in determining whether it was this individual. I mean, there's any number
It's not?
I don't believe so, Your Honor, no. Because while there was an arrest warrant out for Mr. Steverson, and he may have run from the police...
Okay, you don't think the flight gave the police further reason to think this was Steverson?
Your Honor, I suppose that might have given some additional reason. But that was part of the factual scenario we had by the trial judge.
I mean, that cuts against the trial court's ruling, right?
That would cut against the trial court's ruling, but the trial judge evaluated all of the facts in the case, including the flight, and determined at that time that the determination...
Lots of people run away from the police, so that's just not a factor in support of the police officer's testimony.
Well, Your Honor, in general, individuals aren't required to speak with police when they come and when they approach them. SGK versus State, which I believe is a 1995
So basically
case.
what we have here is a factual finding by a trial court that to look at it in a light most favorable to the ruling, to your position, one officer, right? I mean, I take your point that the other officers acting on the first officer's statement, that's Steverson, or, please apprehend him, that's so-and-so.
Yes, Your Honor.
So you have one officer say, I looked at him in poor light, I've seen this guy many times, I thought it was him, I told him to stop, and he turned around and ran away.
Yes, Your Honor.
And the trial court's ruling is essentially that you can't have thought that in a reasonable fashion because, in fact, this guy is not Steverson, and there are lots of differences in appearance.
Yes, Your Honor. Yes, and that factual finding by the trial judge was, again, supported by competent substantial evidence, which the trial judge made findings of fact in saying that there was between...
Isn't it true that, we often hear, in fact, criminal defense lawyers are arguing more and more often that eyewitness identification is suspect, that it is often not reliable. But that doesn't mean the person who makes the identification doesn't think that that's who that is.
Well, Your Honor, if these officers had mistakenly believed, based on this
And
information...
in fact, in a criminal trial, if a victim identifies a person as an assailant, that's competent substantial evidence to support a conviction beyond a reasonable doubt, right?
I believe so, Your Honor, yes. But again, all we have here is the reasonableness of the mistake of identity by the trial judge, which is the factual finding, which was supported by competent substantial evidence. And everything in the record goes to support that conclusion. In the Borda v. State case...
Well, not everything.
No, but there's...
Not the deputy's testimony.
No, Your Honor.
Not the flight.
Excuse me, Your Honor. I don't mean everything goes to support that. I just mean that there is competent evidence to support that. In the Borda v. State case, which is a 2007 4th District case, the dissenting judge was concerned about a factual scenario which is even more disparate than what we have here. We had 110 pounds of difference between the two individuals in Borda, and that court still found there was competent substantial evidence to support the trial judge's determination that it was reasonable, the mistaken identity.
So you must implicitly recognize then as an advocate that even given the comments that the trial judge made here about the differences in physical characteristics, had the trial court simply and without further comment denied the motion, that would be deemed to be affirmed.
Yes, Your Honor. I think there would be competent substantial evidence in the other direction, possibly. But we don't have that here. We have the court granting the motion. And unless there are any other questions, I ask this court to affirm the decision of the trial judge. Thank you.
Thank you.
May it please the court. Briefly, I want to focus on the point where JMO was ordered to stop by Deputy Simpson and Deputy Thompson.
Counsel, let me just, I appreciate your factual argument, but I'm really not sure where it's getting us. If there had been nothing in this case except the two deputies saying, one of them saying I knew him and that was him, the other one saying, yeah, I thought that was him, and then there was evidence about the physical characteristics and the judge had granted the motion, would not that be sufficient? That's all there were of the record. Evidence of the 10-year age difference, 5-inch height difference, 33-pound weight difference, and the officer's testimony that, yes, they in good faith believed this was Stevenson.
If those were the only facts that were available to the court, excluding the geographic location, time of day, the flight.
Counsel, with all due respect, this is not a Terry stop case.
I understand.
Those are factors that go into the evaluation of the officer's testimony, perhaps.
Well, I guess the point I'm trying to get to with the reasonable belief that it was Stevenson is the authority of the officers and the carrying out of their legal duty to serve that arrest warrant, directing JMO to stop.
So we're going to tell the circuit, because we look at what this case does tomorrow, not just what it does today. We're going to tell the circuit judge that if two officers, good officers, and I think the trial court recognized that and probably knew these officers, if they say that they reasonably believe this to be the man named in the warrant, that's the end of the case. That's what you'd like this court to say.
No. The law is that the totality of the circumstances need to be taken into consideration. The physical similarities between a suspect and the actual person. I see my time's out. Should I?
You can answer, sir.
Okay.
Thank you for your courtesy.
Thank you. The physical similarities between a person that is the subject of the warrant and the person that they mistakenly believe is that person, is one factor to be taken into consideration. In this case, there were numerous other factors, such as the geographical location, the time of day, and the fact that he fled, and the fact that there was another person standing next to him that they did not at any time believe to be Mr. Stevenson. So there are other factors other than just the physical similarities that the court needed to take into consideration in this case. And I see my time's expired, so thank you.